Today on LawNext, Reynen Court is a 2-year-old company funded by major law firms that aims to be the app store for legal. Our guest today is Andrew Klein, the company's founder and CEO. This is Bob Ambrogi, and you're listening to LawNext, the podcast that features the innovators and entrepreneurs who are driving what's next in law. And let me just tell listeners that we are recording this live at the International Legal Technology Association convention, and we're in a room that doesn't have the best acoustics. It has a few other rabble-rousers in the background. So if you hear some noises, sorry about that, but that's what happens when you record live. We'll get to today's interview in just a moment. But first, let's hear from the sponsors who generously support LawNext. And now, on to this week's interview. So, Andy Klein, welcome to LawNext.
Nice to be here. Thank you.
I want to get to talking about Reynen Court and everything else you're doing, but I feel like I have to bow down to you because you were somebody who was working as a securities lawyer in a white shoe law firm and left to start a brewery. And I have the ultimate respect for you for that. How did that happen?
Well, I spent a couple of years staring out the window from the 48th floor, trying to imagine how I would get out, and decided that entrepreneurialism was more interesting to me than slogging away. And so I spent some time trying to come up with an idea and settled initially on the idea of building a beer company, and jumped out the window in 1992 and never looked back. Yeah,
it was beer. I mean, were you a brewer? Were you a home brewer, an amateur brewer, or something, or would that just happen to be a good business?
No, I mean, I was a fan of the whole microbrewing movement as it was starting, but I married a lady from the Netherlands, and in one of our long trips discovered Belgian wheat beer, which just sort of struck me as a great product. I don't know if you know what a wit beer is. It's a light-tasting, somewhat citrusy wheat beer, and thought that it would make a good product, and so came up with the idea to brew the first wit beer in America. And
interestingly, out of that grew yet another business. Explain that.
That's right. So, in about year 3 of my beer company, we were growing decently but struggling for venture capital, and I had the idea to try to raise money for my beer company by using the internet, which back in 1995, 1996 was pretty much in its infancy, and I stumbled onto the idea of using the internet to raise capital and wound up using some of the experience I had as a securities lawyer to put together a website and a prospectus, and in 1995 launched what became pretty widely followed as the first ever internet stock offering that seemed like a pretty good idea to me and to some others. And I found an old high school friend that wanted to come in and run a beer company, and I took the chance to start a new company focused on using the internet to help companies raise capital. And in the next couple of years, that grew to be a pretty sizable business because the internet turned out to be a pretty big thing.
Yeah, I remember that. I mean, that was big news when it happened. It was the first of its kind.
It was the first stock offering, and a lot of attention was being paid to almost anything that was happening on the internet back then, and we got a lot of attention, and that led to a lot of traffic.
And so remember, it even got some attention from regulators to some extent at that point. Is that?
It did. In fact, that the regulatory challenge sort of made us a news story, which kept us in the press for a couple of months. But we ultimately got permission from the SEC. The first time the SEC permitted an offering of securities on the internet, and sort of exploded from there.
Yeah. So that led you to get into the finance field more than you had been, or to the capital field more than you had been.
Yeah, that's right. I mean, I had done some work as a securities lawyer in the capital markets, and wound up building out of the beer company's experience an investment bank that we took the name Wit from the beer we made,
Yeah.
which had been called Wit, and we created a company called Wit Capital that
Yeah.
5 years later was a publicly traded company with about 450 people and played quite a interesting role in the first generation of internet companies going public. We co-managed about 350 stock offerings and ultimately sold the company to Charles Schwab, and I went out and looked for something new to do.
Yeah. So then, after Wit Capital, were you living in Amsterdam at that point?
At that point, I moved to Amsterdam,
Yeah,
almost 20 years ago.
Yeah, and then you got involved with as a hedge fund investor. Is that right?
I co-founded 2 asset management companies over the years. One that provided seed capital to hedge funds, and then another that invested in sustainable infrastructure. And so I've done a couple of different things in fairly long period over a couple of decades in financial services.
Yeah. In all that time, not ever back in legal, really.
No, that's exactly right. And by really broad surprise, I wound up just about 2 years ago thinking more and more about the legal industry, really because I started looking for something new to do and was drawn by all the new excitement around artificial intelligence. And I started looking at AI companies, and I started talking to people developing AI, and I wound up hearing over and over again how much opportunity there was to apply AI technology to the legal industry.
Yeah.
And I guess because I understood a little bit about the domain, certainly more than I did about healthcare or medicine, some of the other domains where there was also excitement, I started digging deeper. And the more I saw, I got more drawn into thinking about creating an opportunity in the sector.
Yeah, but what you saw as the opportunity was not to create another AI company, but to come at it in a different way.
Yeah, that's right. What I was astounded by was actually the vast number of companies already developing new technologies, hundreds, maybe even thousands of new ideas. And as I started to think about them more and more, and actually went back and socialized these ideas with friends that had grown up in law school and at Cravath, and we're now still working and in many cases helping run big law firms, I was struck by, one, how excited they were and how interested they were in these developments, but also how challenged they were, primarily because these applications were designed and built to run in cloud computing, right. And yet law firms, particularly big law firms
right.
that serve banks and other big financial institutions, have been greatly restricted in their ability to take the content of their clients and put it up in the cloud.
Right.
And I started to focus on how we could solve that problem and allow law firms to accelerate their adoption of these new applications, and ultimately decided not to pursue a single application, but actually try to build a platform that would help firms and corporate legal departments accelerate their adoption of third-party technology.
Yeah. So you've, at the outset, as I mentioned, you've been described, and I think you've described it as kind of an app store for legal. But explain to me, what is Reynen Court? What's the model?
Well, the App Store analogy we actually like quite a lot. But the App Store, in really the broadest sense, if you think about what the App Store is, the Apple App Store is a good example. It's several things. It's one, a place you can go and find available technology. So you can go and find apps that do things that you're looking to accomplish. You can read about them. You can understand their features and functionality. But you can also buy them on the phone, right. And you can also push the button and deploy the software that literally comes out of the portfolio in the cloud hosted by Apple and deploys onto your phone, and then it runs in a safe, secure way and actually interoperates with other features and functionality running on your phone. And so we're taking that same experience and we're building it to apply to an enterprise software environment that's actually far more complex, but we think can work in very much the same way. So we have a platform that really has 5 core pillars. One, It's a place you can go and find information about available technology and even buy licenses to technology. So that's the store.
Right.
But two, it's a whole operating system for the code you're buying to actually deploy into your environment that's under your control. In the case of an enterprise, it's not your phone, it's actually a cloud, what we call a private cloud, that's maintained and operated and controlled by the law firm, as opposed to a SaaS environment where the vendor is offering a solution where the cloud is actually integrated into the application, but under the control of the vendor. So that enables you to take modern cloud software, but run it in an environment that you control. You have the encryption keys, you control network access. So you bring the code to the data instead of having to push your data out and trust it to the vendors of the software. So that container orchestration environment, which is a technical term, it takes a new kind of software deployment and basically makes it easy for a law firm to take software and run it without having to put their data or their clients' content out at risk in the cloud.
Yeah.
Three is it's a full service automation environment where you can in one place manage the subscriptions and the provisioning of the licenses. So you have 1,000 lawyers and you buy 1,000 licenses. Well, which lawyer gets the license? Which lawyer, which paralegal, which support staff? So the process today is very manual. You go to each software platform and you can configure and provision software. We're going to enable that to all happen through one platform in one place. Four, telemetry. Once you're now running all these applications in your private cloud with all this automation, we're going to be able to generate data about the cost and usage of the apps and the cost and usage of the infrastructure consumed in running the app and flow that into the billing systems, practice management systems that firms use, so that when you start using more technology in matters and cases, you can figure out who's going to pay for it. Are you billing for it? Are you just assuming those costs but need to price matters in a way where you have a healthy business, even though you're using more technology? It's not just free. Someone has to be covering those costs. So firms today struggle to get the data about the actual costs for using the technologies that they use. And so we're providing, because we're now sitting on top of the infrastructure and the apps, we can provide the data that help firms bill or account properly for the technology.
Yeah.
And then finally, interoperability. As you have more and more technologies that need to get data from your document management system or add content to your practice management solutions, how do you make it easier when you adopt a new technology with one click? Now you can buy it, deploy it, but now it needs to connect to your anchor systems. We're creating pathways to create easier, more efficient interoperability between and among applications. So you put all it together, and it's really an enterprise app store that helps law firms adopt more quickly, more efficiently, but also more safely new technology.
Right. So as we're sitting here at ILTA in the middle of August, and you just last week introduced the beta version of this, like sort of a phase one beta, I guess. Where are you in those 5 pillars? What's in the beta? Where are you at this point?
Yeah, so the beta is quite robust. It touches all 5 of those pillars. We've gone live on Thursday with 5 law firms. We have over 50 third-party apps that are in the platform. We have another 45 or almost 50 that are working towards being in the platform. So we've got a nice collection of products available, a lot of functionality. We're starting slowly with 5 firms because we want to make sure that it's up and running and stable. The plan is by January to have a full commercial release, and so the second release is targeted for a couple of months from now. The functionality will keep improving, and the number of apps in the catalog will keep growing. But we're off to a pretty good start. We have almost 50 firms that are in the contracting mode to begin to use the platform as soon as it's declared ready to go robustly.
Yeah,
so,
and I don't know if I mentioned this at the outset, but Clifford and Chance, Latham Watkins were 2 of the kind of leading firms that led the initial, I guess they were the A round investment in this company, and there's a consortium of firms.
Yeah, that's
are,
right. So my big challenge in the beginning was to figure out how I could get the application vendors to cooperate. The application vendors liked the idea, but without clear guidance that there would be firms interested, it would have been a hard sell. So the strategy I took, this is going back about 18 months ago, was to first focus on getting a large number of influential, important firms to support the idea.
Yeah.
And so we created what we called a consortium. 19 of the largest law firms in the world signed a 3-year commitment to participate in really helping us define the requirements and helping us communicate the opportunity to the vendors. And that's gone extremely well. We have those 19 firms that have played a huge role. Among those 19, Latham and Clifford Chance and thirdly Paul Weiss played roles as chair of the consortium and really helped us guide the governance of that collective body. In December,
and put skin in the game too. I mean, they invested financially.
And then in December, Clifford Chance and Latham and Watkins both participated financially, separately from the consortium activity, but offered to invest in the company and our shareholders as well today.
So what is the pitch to vendors? Why would vendors want to be involved in this?
Well, vendors see lots of benefits. Actually, I think that's why they've joined on. Obviously, they've been urged to take it seriously by important customers, but for a vendor today that's supporting on-premise software deployment because the big firms refuse to go to a SaaS cloud deployment, there's a tremendous amount of labor and attention required to support all these different law firms. Engineers and support people spend a lot of time and effort making not only the initial deployment, but every version of software that's released has to be installed manually, physically. Very expensive, very inefficient. So with containers, they can release once software and it can run anywhere. They don't have to customize the deployment for different environments. They don't have to worry about how it scales. They literally build once and it can run anywhere. So it's greatly efficient on the deployment side. Beyond that, the flip side of all of the pain and agony that the firms go through in adopting a new application is shared by the vendors, because to get a big firm to adopt a new software product, the software vendor has to fill out questionnaires, be subject to security tests, negotiate bespoke contract terms, and it takes quarters. Literally, it could take a year to get from idea and interest to a live deployment. The law firms are spending $50,000, $75,000 internally just to get a new application to the point where they could run a pilot. The vendors have to spend an equal amount of money on their side serving those law firms. So by getting on our platform, going through our evaluation process, we can help the law firms and we can help the vendors, because if the vendor satisfies our standards and meets the requirements that the firms have helped us define, then the firms don't need to bug the law firms with their own questionnaires, with their own testing, with their own auditing. So they get curated in our platform, and the law firms are going to take that as good work product that they can rely on. It'll mean the vendors have to do a lot less to get through all the hoops they need to jump with. It won't be magic. They're still going to have to have a buyer that's interested in, and they're going to have to be available to serve firms. But the process, what we see is that the same questions, the same tests are being done over and over again by each firm for each application, and the application vendors have to go through that process time and time again. We can take a lot of that friction out of the process by just being trusted as a third-party intermediary to just do good work on behalf of a whole collection of law firms. We abstract each law firm from the point of view of the vendor, and we abstract each vendor from the point of view of the law firm, so that they can each do the work that they need to do in a more consistent way.
Yeah, and what's the sort of the vetting, I guess, that you're doing of the vendors? I mean, what does it take for a vendor to be able to participate? Do they have to have? I mean, they have to be willing to do the containerization and all that, I guess.
Well, the vendors can put containerized products on the platform. They can also put SaaS offerings. In fact, many vendors will offer both because there will be different customers with different levels of sensitivity to security.
Right.
There will be real advantages to SaaS offerings in some cases, either because the content is not that proprietary or critical, or a law firm serves clients that don't have that same exacting, demanding set of standards. The banks tend to be, very, very security conscious. There are other types of clients that are much less so. So we welcome all cloud software, SaaS or containerized. We essentially do the same type of curation, evaluation, analysis work that any single law firm does. So we have a series of questions about the vendor. What's their financial history? How many employees? How long have they been in business? What are their practices for releasing software? So vendor compliance is one topic. Application security is another. So we actually take the containers and we test them, and we publish the results of the tests. Same thing any one law firm would do.
Yeah.
We benchmark the software. Interoperability. What does it interoperate with? How hard is it to deploy? How hard is it to configure? How hard is it to train? And how hard is it to drive real adoption? So we have people with some expertise that are then doing that analysis and then interviewing customers, surveying the market, and then writing analysis up on categories and specific apps so that we're pulling together educated points of view and experiences of other users of the technologies and providing all of that. It's not the vendor's view of their own application. It's our view. It's intended to be fair, but it's our view of what we've learned, just like any one firm would go and try to figure out what their view of an application is. We're publishing that, and then firms can take that and do more work if they feel it's an important application and they want to make it a big part of their technology stack. They'll do a lot more work. But if it's an app they need to do a deal on Thursday, then our evaluation and the model contract terms and the ability to buy it and deploy it instantly will be real benefits. And more we're seeing technology decisions that have to get made in transaction at your Friday afternoon, and the due diligence team is beginning to dig into a real project, and the lawyers find out that they need to read 100,000 bank statements to find out where the risks are for an acquisition. If they were to find out at that moment that there was a new machine learning app that could do that efficiently, it would take 9 months before they could get it actually deployed because of security and contracting. We want to reduce that from months to minutes, so they can click, learn about it, click, buy it, instantly deploy it, and start running it, and all the while calculating the cost and the usage so that they can put in the monthly billing run.
Who's doing the buying here? Is the firm directly contracting with the app developer, or are they? I assume they're paying you some subscription as well.
Yeah, that's right.
How does the financials work around this?
Yeah, so two related but separate questions. So all of the contracts are between the app vendor and the law firm, but those contracts can actually be consummated on our platform. They can also be consummated.
They're standardized, I assume. They're not going to be bespoke contracts, or.
Well, they're on the platform. They are standardized. That is, the contract that the vendor offers has to be accepted, and like in any e-commerce experience, the click is the buying act, but the terms have to be defined, the price has to be defined, and there's a meeting of the minds that can happen on the platform. But it's equally permitted for the law firm to pick up the phone and call the vendor and negotiate a separate contract off-premise, off-platform, and then bring the license they've just bought and registered on the platform and bring to life all the functionality. So both are permitted. Our economic model is one, we get an annual license fee from the law firm for unlimited use of the platform, and secondly, the vendors can put their products on the platform and make them available through the platform for a modest annual maintenance fee. In addition to that maintenance fee, if the vendors choose to activate the buy button and put subscriptions for sale on the platform, and the contract is consummated on the platform, then we also get a share of the revenue from the vendor.
I see. And are the law firms also paying you a direct subscription fee to participate in the platform? Yeah.
Fixed annual fee per law firm per year.
Okay.
Yeah, that's our primary revenue.
Yeah. And what happens if a law firm tries out an app through Reynen Court and says, well, we really like this, but we don't want to use it through Reynen Court anymore. We want to just deal with them directly after we've used it for a couple of months or something. Are they in any way obligated to continue working through Reynen Court on this, or?
Well, so make sure I understand the question. So,
what if a law firm wanted to just use Reynen Court as sort of a testing ground for new apps, but then once they decide, this one I didn't like, but this one I really like, and I want to deploy it more widely in my firm, so I'm just going to go call the vendor and say, let's forget about, accessing your app buying your app through Reynen Court. I just want to enter a deal with you directly.
Yeah, so to be clear, the law firms can always buy the app directly and register it and have full use of the functionality on our platform. If they don't want to pay us the annual fee, then they would lose that functionality. So as long as they're paying us to use the platform, we're indifferent to whether they buy the app through us or buy it around us. If they, in fact, buy the app on the platform and then decide that they want to stop buying it through the platform and renew it off the platform, then we would still get paid a revenue share because our contracts with the vendors protect us against people kind of using the platform to buy the app in the first instance and then taking off platform. Yeah. But it's equally true that the vendor and or the law firm could decide from the start that they would prefer to contract outside of the platform, and that's perfectly fine. We're primarily earning fees from the law firm, and our allegiance, if you will, is to be a good service provider to the law firms. Yeah. The vendors are making their products available because their clients want their products to be managed in a central control panel, and they want the API access, and they want to manage containers in their private cloud, and they don't have another way to do that today.
Yeah. We'll get back to my interview in just a moment. But first, let's take a break to hear from the sponsors who generously support LawNext. And now, let's continue this week's interview. And we've been talking a lot about containers here, and I'm not sure everybody knows what a container is even. So could you just explain the concept of what we're talking about when we're talking about developing containers?
Yeah. So containerization is a technology approach that's been around since about the mid 1970s. That in the last 4 or 5 years has really come to the mainstream, mainly because Google adopted containers as a way to get more efficiency out of the way they operate their data centers. And in the last couple of years, Google gifted the technology to the open source community, and ever since that gift, it's been embraced by all of the big technology players as really the mechanism that will make software scalable and portable so that it can run in the cloud. Why Google developed the technology and their objectives is really quite clear. They run enormous amounts of infrastructure, and they've figured out that they could build automation that would basically manage the scaling up and the scaling down of applications running across their infrastructure in a way that would be far more efficient than the traditional way of doing that with engineers connecting boxes together. The analogy that container movement took was to shipping containers. That's why they call the leading product in the container space is Docker. If you think about the shipping industry, that's really where the analogy comes from, but it makes a lot of sense. Yeah. So think back, 50 years ago, you could ship freight in a box of any size, shape, or form. You had a piano, you could ship it. You had a small a bottle of something, you could ship it in a package. And when all that freight got to the freight pier, people had to manually load it onto the ships and then figure out how to balance the loads. And it was all very tedious and manual to get a ship fully loaded and ready to sail.
Yeah.
They came up with the idea of a standard shipping container, and all of a sudden you could pack, households, commodities, anything, and it all came to the port in a standard unit of containment.
Right.
And then they started building shipping loading automation to run the shipyard, and now you had trains showing up and cranes moving and boxes being loaded, and no one was doing any of it. It was all being done by automation.
Yeah.
So apply that vision to the software industry. So Docker is the industry standard today for, think of it as just the shoebox. It's a unit of standardized containment, and software applications are basically put inside the shoebox.
Yeah. And everything that's needed to run those software
everything
applications.
that's needed to run those applications, the libraries, the files they need to access. It's like a mini operating system is appended to the software, and it's put in a box that nothing can penetrate. Those boxes then are dropped on top of servers, infrastructure, and here's where the magic comes in. The software that Google built, which was originally built only for Google, gifted to the open source community. Today it's called Kubernetes, which is a mouthful, but that's the leading standard for what's called container orchestration software. And that's really the magic, because what Kubernetes
Those are the cranes
does
that are unloading
it's the automation that basically moves all the containers around and figures out where you have capacity to run them and pushes them to the right server, and when you don't need that server running there anymore, it literally it deletes the container, it clones containers. So if you have to accelerate your run and you want to have 5 versions of that, it just clones them, and you don't need anything from the vendor of the software except one container, and you can multiply it and you can scale it back down, and it literally magically matches the need for compute power with the available compute, and it optimizes for the running of the infrastructure.
Yeah.
Google built that over 12, 14 years and gave it away to the open source community. Why did they do that? Because they want all the data centers to go away, and they want all the compute to move to their cloud.
Yeah.
They know that AWS and Microsoft and some others will share some of that, but the cloud business is booming, and there really are only 3 main players. They've all adopted these cloud native technologies as the core, because they're going to enable every software developer to build software once, and then it can run in any cloud environment, and that's what is really driving our platform is the availability of those core technologies that make software portable and allow the customer, the client, the law firm in this case, to bring software down and run it wherever they want to run it, but in a very modern, very highly automated way.
Right, so it addresses the security concern, it addresses the deployability concern, it just gives the firm more flexibility. Really.
Yeah, and when they start, as they are now, moving to third-party hosted, what are called virtual private clouds. So that's a private cloud segregated for you, but hosted by Microsoft or AWS. It gets even better, because now they don't have to build out a server farm to accommodate the peak amount of compute that they're going to need. They can actually buy what they need when they need it, and then not, keep it on the shelf for another day. And so, come back to my original interest in the AI sector. Why is this so important? Because so many of the new applications have an elasticity of computing needs. So you don't need 1 million servers sitting there to be used for 4 hours once a week. When you need those 4 hours, you can just buy that compute time at a cloud vendor, scale it up, and then scale back down. It's expensive per minute, but you're not buying more than you need. And so you don't have all those capital investments in building all the servers.
Yeah.
You don't need the real estate to house all that compute. And you don't need all those security engineers. Google has 600 security engineers. They're working every day on protecting those environments.
Yeah.
The average law firm is going to be well better served outsourcing to private clouds the infrastructure and then bringing the compute code down to run in their infrastructure, and using modern automation to manage all of that. And that's what we're building.
One of the 5 legs you talked about was interoperability. How does your model promote interoperability? I mean, is it just APIs, or is there something more?
Well, there are many initiatives behind that. So the low-hanging fruit is that there are many applications that need to pass data to or get data from other applications. So you're running a document management system and you have a transaction management system, and you want one to be able to speak to the other. Every application has a data model. What fields and what are the formats of those fields, but they're all different. So applications are being built by many different third-party vendors that simply connect the two. They translate the data models from one app to another. Those can be containerized themselves and available off the shelf. So if you're buying product A and it needs to speak to product B, product C is actually a connector that just makes that reusable. So it's doing work that today every firm is doing as bespoke custom code development to integrate two solutions, and we're just productizing it. So it will be available to be pulled down. You want A, you want B, you need C to connect the two, and you can do all that with a few clicks. And there are a lot of those connectors already on the market. In fact, there are many vendors here at ILTA that offer those products. Secondly, we're building a data hub. A data hub is essentially a translation table so that once a new application is mapped to a standard data model and all other applications are mapped to that same standard data model, you don't even need the point-to-point connections, because you actually have essentially a lookup table so that app A is translated into the data model of the core, and app B is translated into the data model of the core, and the two data fields are basically connected together. So we believe a data hub will be a foundational piece of the plumbing.
Yeah.
The other thing that's very key in the efforts the law firms are making to drive greater adoption is more consistency to how applications are trained and what the workflows or user experience is of an application. So I'll give you a good example. There are already 15 or 20 contract review platforms that have some form of AI or machine learning that analyze documents and push back results. Most of those tools come with some integrated workflow management tool, which means every time you want to try a different back-end review solution, you need to learn a new workflow management tool, more training required, less familiarity. What law firms in our group are very interested in is the introduction of independent tools, like an independent workflow engine, for example, where you could teach people how to use workflow tools and then have universal workflow tools that can basically be connected on top of many different types of applications. Law firms have not really had a long history with workflow automation, but in many other industries, there are very mature products that actually don't do any business application. They just help organize projects and workflows. And we believe there's going to be a great renaissance of workflow automation in the legal sector.
So instead of working on Kira, say, you're going to be working on a workflow application and reach out to Kira at the point that you need to reach out to Kira.
Yeah, because if you think about it, contract review systems are really back-end engines. You know, the valuable part of that is the training of those algorithms that read through 100,000 documents and find what you're looking for. But how do you feed the document in, and where do the results show up, and what do you do with the output is actually something you could standardize quite well. And it's interesting, if you think about the consumer app experience, you can give a 10-year-old an iPhone today and even give them apps that they've never seen before, and they know how to use them because they're shared functional.
Right.
And that's very, very, very important to understanding why so much legal tech is stalled. It's hard to use.
Yeah.
And the more things a platform does, the harder it is to teach people how to use it. And so what we believe and what we're seeing is that the best apps tend to be single-purpose, narrowly focused. And the same company could have 10 apps, but they're better off having 10 apps than having one platform that does 20 different things. Because one of the real challenges to all the legal tech vendors is getting real adoption. And so the usability of the tools and the number of things you need to learn before you can start are real friction points and so universal workflow engines, more standardized user experience is something that we think will drive interoperability a great deal. Some of that we can impact at Reynen Court, and some of it we can't. We're not going to be able to redesign every user interface, nor would we claim the expertise to really understand every user experience. But large law firms that are putting great effort into buying technology know that they have to put even more effort into driving real successful adoption. And a lot of that has to do with how hard is it to train and how hard is it to get a new user to have a good experience, because lawyers are busy, they're under a lot of pressure. The last thing you want is to do all that work to put a solution in the hands of a lawyer, and then in the first 10 minutes you're like, I don't even know how to do this, and then it doesn't help anybody. And so by making the apps more single purpose and more divisible and making them more plug and playable, we think there'll be a lot of progress. And that's
it seems to me there are probably
strategy.
certain kinds of applications that are never going to be, certainly never going to be containerized on Reynen Court. I mean, like NetDocs or iManage or something. I mean,
well, it's a great question. So NetDocs has a cloud-only strategy, and they're very supportive of Reynen Court, but not because they want to put a container of NetDocs. But interestingly, what they believe, and where we're very aligned, is they believe that the 114 apps that need to interoperate with NetDocs need to have a strategy where they're going to run when the data center goes away. Because today all those other apps are running in the data center, and they're then connecting to NetDocs remotely. The actual architecture that NetDocuments and frankly iManage and Relativity, I think, share the same view, is that there should be a few big SaaS vendors. They all expect to be one of those. And then there'll be lots of other edge applications that need interoperability with those. They should be containerized. They should run in one or two private clouds, and then you should have a thick pipe connecting the private cloud with the anchor system so that there's no issue of latency and instability.
So your visions are consistent in that way.
Very consistent. In fact, we're working on a partnership path with all three of those companies. iManage, we'll see. iManage has, for the most part, on-premise customers, at least among the big firms. They almost all use iManage on-premise. iManage is trying to move them all to the cloud. They've had some big wins. Clifford Chance, most notably, chose them and is going towards their cloud solution. We will see whether there's a movement to bring an iManage container into a private cloud, or there's a movement to the iManage cloud. In either case, we believe, and I think the iManage management would confirm this, that all the other apps, and in the case of iManage, I think it's over 300 apps that have interoperability with iManage. We're trying to focus on the question, where are all those apps going to run when there's no more data center inside the law firm. And we believe the answer is in a container,
Right.
in a private cloud with connectivity to the iManage cloud
Yeah.
or the Microsoft cloud
Yeah.
or the NetDocuments cloud. And
Yeah.
I think that's more likely to be the end result than 500 different SaaS environments all trying to pass data back and forth
Yeah.
without any stability.
Yeah, the consortium that's involved so far, large firms. Does this model extend down into mid-sized and smaller firms?
We believe it does, and we're working on our plans to begin that offering to the mid-tier. How far down it goes, I don't know. Firms that have big clients will have similar needs for the same types and the breadth of applications. Smaller firms that serve big clients, we think, will be great prospects for us because they'll have even less resources and need more help in being able to compete on an equal playing field in terms of the technology and the tools that they have. Smaller firms that serve smaller businesses and do different types of legal work may need a completely less sophisticated solution with far less
Right.
technology because of the nature of the work that they do. So we're very focused on law firms and legal departments that do big corporate work because we think that it's really the work that's being done that will drive the technology mix more than the size of the firm.
Yeah.
How we will bring the solution to the mid-sized firms is where we're really still thinking. It could be indirectly by working with systems integrators and consultants and managed service providers who already have lots of relationships and lots of people out there to do the consultative work because there's still a need for help, and the big firms, as you know, have large teams and big budgets to employ really competent experts. The mid-sized firms are under much more pressure to get more done with less expense, and so consultants and managed service providers, I think, will play an increasing role
Yeah.
in helping. Because there'll be more solutions, not less. There'll be
Yeah.
actually more things that firms need to do. And if you have a small IT department, that's challenging.
Yeah. I've kept you way longer than I'd planned to here, but just real quick, what's next? You've launched your beta now, so what's next for?
Well,
Reynen Court?
we're just in full on execution mode. We have a lot of work to do on the features and functionality on the platform. We're working very hard to deploy it now to more firms that are lined up to become customers, and we're gaining more apps every day, every week. So we have a lot of work to do, but so far so good.
A lot of interest here at ILTA at what you're doing. I've already had a lot of conversations with people about it. I know there's a lot of people watching it with a lot of interest. So congratulations, and I guess welcome back to the legal industry.
Well, nice to be
Yeah,
back.
you didn't bring any beer to sample, though, did
No,
you?
not
Too
plenty of
bad.
beer out there in the world, I'm
Great.
afraid. Yeah.
Well, thanks a lot. We've been talking with Andrew Klein, the founder and CEO of Reynen Court, which is named after the street you grew up on. Is that right?
That's
Or
right,
is it
Richmond,
named-
New Jersey.
Let me just again thank the sponsor, one of the sponsors who keeps the show running, My Case, with thousands of customers, is a trusted practice management solution, helping lawyers across the country run organized, efficient, and successful law firms. Try it today at mycase.com. And as always, let me thank our producer and editor, Bob Ambrogi, for his hard work in getting this show done. And that's it for this week. This is Bob Ambrogi.